Well, good evening, and I am incredibly privileged to be here. I had the happiness to meet Edward Said on one occasion, and my late father-in-law was his publisher for some time in the United States, and always spoke incredibly glowingly of his intellect, of his ideas, of his humanity, of his warmth. It's incredibly nice to be here today. My background is as a public international lawyer. So I also happen to be a member of the English Bar. When you're given an instruction, which in my case was, answer the following question. What can international law offer to change the current reality? And speak for no more than 10 minutes. As I told Hassan, international lawyers get very used to cultural difference, and we interpret rules differently, and that's fine and wonderful. So I will limit myself, because this really is a topic you could talk about for hours and months and years, and many people do, and it's important that they do. I'm an international lawyer. I have been for 35 years. I teach it. I litigate it before international courts. I act for, advise many different governments all over the world. But I'm not starry-eyed about international law. Just this week, in fact, I've gone through an experience which teaches me that the subject we're talking about here is not a singular or unique experience. For the last 10 years, I have acted for Mauritius in proceedings against the United Kingdom in relation to a place called Chagos, which many of you will never have heard of. It also, thank you, it also is the home of a US military base. Chagos is an archipelago in the Indian Ocean, a tiny place. It was, from 1815 until 1965, a part of the British colony of Mauritius. In 1965, Mauritius was given independence, but Her Majesty's government said, in giving you independence, we'd like to keep a little bit of you. Sign on the dotted line, take a few £100,000. And for 50 years, Mauritius has sought to recover its territory on the basis of the right of self-determination. The very same principle that Hassan has talked about earlier this evening. And we managed to get the case to the International Court of Justice, amazingly. And in February of this year, we got a ruling from the International Court of Justice, which says in clear terms, explicitly, the United Kingdom shall cease its illegal administration of the Chagos archipelago and remove itself as rapidly as possible. So that was a big result. But of course, what happened? We waited and waited to see what the reaction would be. We know that the United Kingdom is the most law-abiding country in the whole world. There is no country in the world that is more committed to the rule of law than the United Kingdom. There is no country which tells others to go to the International Court of Justice, to comply with advisory opinions, to submit yourself to international jurisdiction. On Monday of this week, the Foreign and Commonwealth Office actually didn't dare to turn up in person. They submitted a written statement in the House of Commons, which said, we will not be complying with this ruling. We will not be complying with this ruling because of national security. We need that base. We need that little piece of land and that particular territory. And the matter will now go to the General Assembly, and the United Kingdom will have to defend itself in the General Assembly, having turned itself essentially into a lawless, perhaps even rogue state when it comes to matters of international law. But I don't give up, and the Mauritians don't give up, and the entire continent of Africa doesn't give up, and the dozens and dozens of other countries. It is a long game under international law, and that's really what I want to talk about. International law, in its modern sense, came into being really only in 1945. Until 1945, if a country adopted a rule which said everyone on that side of the room will be executed tomorrow at 6 p.m., international law was silent about that. A state had absolute sovereignty over its citizens. What changed in 1945 was the idea of individual rights and group rights emerged, incorporated into the Charter of the United Nations, incorporated into a whole raft of treaties and instruments. And the bottom line of it is you cannot imagine for a single moment that you're going to change the world in 1945 and all of a sudden the vested interests, the governments, the states, the emperors, the republics, the presidents, are just going to keel over and say, oh, okay, right, it's all changed. We give up, we're just going to give it all back. It doesn't work like that. It's a long game. I had a colleague when I used to teach at Cambridge, Sir John Baker, professor of English legal history, and occasionally we'd have lunch. And he'd say, I was in my late 20s, what are you working on? What sort of things are you working on? And I'd say, oh, I'm doing this, that, the other. And he'd say, yes. We had a similar problem in English law in 1472, and it took 250 years to sort it out. So law is a long game, and international law is a long game. Now, when you apply that starting principle to the situation of Israel and Palestine, you come to it with a high degree of sanguinity. You don't give up easily. There is not a single issue that has been raised this evening that doesn't have a component about international law. The creation, originally, of the State of Israel, as was touched on, the right to self-determination of Palestine and Palestinians, the right of return, the rights of compensation, borders, placing embassies in Jerusalem, Golan Heights, the use of force on both sides of the story, occupied areas, treatment of Palestinians outside the recognized territory of Israel, treatment of Arabs inside Israel. And the list goes on and on and on. So if you want to talk about international law, you know this far better than I do, Hassan. You deal with it every day. It is a lifetime I could be standing up here talking to you. But things are happening, slowly. There are cases that rise to the international domain. In 2004, the International Court of Justice gave a very important advisory opinion, almost unanimously, in which it ruled that certain aspects of the wall and many aspects of other things, including settlements, were illegal. It has not been fully implemented, plainly, but that doesn't mean it's useless. It provides a frame of reference that people in the 1920s and 1930s did not have, and that is transformative of political process. It's not determinative, but it's significant. It's not nothing. Palestine has ratified the statute of the International Criminal Court. It is trying to persuade the prosecutor of the International Criminal Court to investigate certain things going on its territory, which it says are at the instance of Israeli forces and others for acts attributable to the State of Israel. But of course, the law is double-sided. And if that court exercises jurisdiction, it will look at things on both sides of the story. You use international law and you go in with your eyes open. Judgments have unintended consequences. Judgments apply on both sides of the story. It's never an entirely one-sided outcome. Palestine has brought a case right now, very recently, as we know, to the International Court of Justice to challenge the decision of the United States to place its embassy in a certain part of Jerusalem. The first thing the International Court of Justice will have to do is decide whether it has jurisdiction, because the United States says it does not accept the ratification by Palestine of the relevant international convention. Even if Palestine doesn't succeed in that case, and I'm not saying it won't, these things are complex, it gets the issue into another forum, and slowly, inch by inch, things move forward and a political dynamic eventually takes place. For the purposes of tonight, I wanted to just focus on a single issue, which is connected to themes I wrote about in a book I published recently called East-West Street, which tells the story of the origins of two concepts, genocide and crimes against humanity. Those are concepts invented in 1945. They have not existed since time immemorial. Genocide, invented by a man called Raphael Lemkin, is about the protection of groups under international law. Crimes against humanity, termed as a legal concept in 1945 by Hersch Lauterpacht, is about the protection of individuals. And each of us know there is a tension, always, between the individual and the group. The book has been translated into many languages, more than 20 languages, all the UN languages. I'm sorry to say not yet Arabic, but I hope that changes. One language it's about to be published in next week is in Hebrew. And I've been asked to go and give 2 lectures, which I will do. And I will talk about the individual and the group. And so I've immersed myself this week on the issue of individuals and groups. And I was drawn to the very piece of legislation, the basic law, with the title Israel, the nation state of the Jewish people, which declares in its Article 1, and I quote, "The state of Israel is the nation state of the Jewish people." Strikingly, from the perspective of an international lawyer, not a domestic lawyer, within Israel, that act has no provision on equality. And for an international lawyer, alarm bells begin to flash in that context. Questions have been raised, very understandably, I think, as to whether the intention and effect of the new law is to undermine certain rulings of the Israeli Supreme Court, which have said in terms that a citizen of Israel will not have more rights merely because she or he is Jewish, or that a member of another group will have less rights for that reason alone. The Israeli Prime Minister said recently, in relation to that law, which is being challenged, I believe, in response to a comment by a well-known Israeli actress, that, and I quote him, "Israel is not a country of all its citizens," end of quote. Now, when I hear words like that, having immersed myself for 10 years in writing East-West Street, which looks at the history of events in the 20s and the 30s and the 40s, I'm drawn immediately, when I hear dark words like that, to a writer who knew what it meant to be on the receiving end of a place, Italy, where you distinguished the rights of a citizen depending on certain aspects of race or religion. His name was Primo Levi. Primo Levi experienced firsthand in Auschwitz, as he wrote in the preface to his book, If This Is a Man, which was published in 1947, and I quote, "Many people, many nations can find themselves holding more or less wittingly that every stranger is an enemy. When this happens, when the unspoken dogma becomes the major premise in a syllogism, then at the end of the chain, inevitably, there is the concentration camp." And that was what the moment in 1945 in international law tried to do, to say you cannot do that in relation to individuals, and you cannot do that in relation to groups. So let us not be starry-eyed about international law. Let's keep our expectations in check, but let us not say that because it has not yet delivered, it is useless and it should be consigned to the garbage can. It provides a framework, it provides a point of reference, it legitimates certain arguments and delegitimates other arguments, it provides options for solution. It is a sword and it is a shield, but it is not yet mature. It has a vital legitimating function, and we must not give up on international law. Thank you.